Hi, everyone. As you know, my name is Brian Kanoski, and I'm a partner with the Federal Appeals firm, and we handle federal disability appeals. I wanted to take this opportunity to talk about the newly enacted SSR 24-3P, which is a new rule that a lot of attorneys and representatives have questions about and what the impact of this rule will be. So I want to talk about it a little bit and discuss my thoughts on the rule, since going forward, this rule actually may have quite a bit of impact on how Social Security disability hearings are handled and how attorneys and reps should approach hearings as well now under the new SSR 24-3P. So I think to start with, I'm going to share my screen and bring up some of the information that I have here. So we're first going to start with showing you the new SSR 24-3P has an effective date of January 6, 2025. So it was just established and became effective right at the beginning of 2025. Now, so what I did was I copied and pasted this entire rule into Word so that I can make some notes and take you step by step on and talk about some of my thoughts on the new rule. So here's a new rule, which I have in Word, and I'm going to take you down through some highlighted portions, which I think are important. And here, what we have is a notation. Like right here, it says that the Social Security Administration is rescinding SSR 00-04P, meaning that it's no longer requiring the adjudicators to identify and resolve conflicts between occupational information provided by vocational experts and the information in the DOT. So this is important here because it means a couple of things. Normally, when you're dealing with testimony at the administrative level, the vocational expert must resolve any conflicts with the DOT. It must say in sum and substance that they're aware of their testimony departed from the DOT and that there's a conflict, why there's a conflict, and why they testified the way they did. That seems to be something that's now going to be eliminated, and that requirement does not seem to exist any longer. And in part, the reason for that appears to be that Social Security is recognizing that the DOT is an old and outdated document, though it's still relied upon, but that the vocational experts now can rely on other information as well, other documents, other treatises, even their own professional training and experience. And so they're no longer reconciling their opinions with the DOT because the DOT standing alone is not the only controlling document any longer. And what we have here is a notation that there's federal statistical data related to work in the national economy, and that comes from the Standard Occupational Classification System, also known as SOC. What this means is this is another document that vocational experts can rely upon. And you as a practitioner should be aware of this, because if the vocational experts at the hearing are allowed to rely on this, then you should be prepared to potentially cross-examine the vocational expert based on any testimony they give based on the SOC. So you should become familiar with the SOC because you may have to ask questions and cross-examination questions based on that. And furthermore, the rule states we do not want to discourage use of occupational information that's reliable and commonly used in the vocational profession. Again, that refers back up to the SOC, but this could also relate to any other set of documents or treatises or publications that are considered reliable and commonly used by vocational experts in the vocational profession. So you are not limited any longer to the DOT. So we're going to scroll down a bit here. And again, it says vocational experts may use any reliable source of information, occupational information that is commonly used by vocational professionals and is relevant under our rules, along with their professional knowledge, training, and experience. So you have to be prepared. Vocational experts could very well start giving answers based on their training and experience, and you may need to be able to cross-examine on that to explore what is their training, what is their experience, where are they getting this information from? Are they just talking to other people in the industry? Are they getting this information from colleagues that they've talked to? Are they getting this information because they're out in the field and they've been at places of employment where they're gathering that information and then they're incorporating it into their own knowledge database? So is it based on hearsay, which of course hearsay is probably going to be admissible in a Social Security hearing, but you could argue that it goes to the weight of the evidence. And so you really need to be prepared to cross-examine a vocational expert on the source of their knowledge so that you can challenge that. Now, they can rely on other sources of occupational information other than just their personal knowledge and professional training. And that would also mean, like we discussed above, that could be the SOC, it could be the ONET, and it could be more. So again, you're no longer limited. You now can actually cross-examine based on ONET, where before there was some reluctance for vocational experts to give answers based on ONET, but judges to even allow you to question based on certain other treatises and documents, because everybody always took the position that the DOT controls. But now you have also a wider range of data to use. We're going to come down a little further, and this has to do with vocational experts offering estimates of job numbers. The Social Security does not dictate any specific approach to estimating job numbers, and the job numbers provided are only estimates. Vocational experts may provide evidence based on their professional experience and reliable source of occupational information that's commonly used and relevant under the rules. However, it goes on to say, we expect vocational experts to identify the source of the data they use where applicable and explain their general approach to estimating job numbers. So this raises a question then as to whether or not now, when a vocational expert gives a job and they say how many employees there could be or jobs available in that particular occupation, let's say it's 10,000 jobs, 15,000 jobs, whatever the number is. The question is, what are they relying on to formulate that number? And so this here seems to indicate to me that the ALJs must explore the methodology of how those numbers are in fact derived. So there could be an argument, and again, there may be litigation going forward on a lot of these issues. We don't know how they're going to shake out just yet, but there could be an argument here that where the ALJ does not explore the methodology, that at step 5, the record is just insufficient and incomplete. So here it says, we expect vocational experts to identify the sources and where applicable, expand their general approach to estimating job numbers. They're to give the basis for the estimated job numbers in order to establish that there are a significant number of jobs in the national economy. The failure to provide the methodology, in my opinion, the way this is written anyway, would render a step 5 finding potentially or arguably defective. Again, subject to future litigation, but we'll see how it all shakes out. But here is really where I think this rule oversteps its bounds. Right? So here it says, at the hearing level, when the claimant is represented, we expect that the representative to raise any relevant questions or challenges about the VE's testimony at the time of the hearing and to assist in the development or developing the record through appropriate questions to the VE. This bothers me quite a lot, quite frankly. I'm not quite sure where the government is going with this aspect of the rule. This seems to place quite an onus on attorneys and representatives to actually take affirmative action and ask questions of the vocational expert. To me, this section here is an attempt by the Social Security Administration to create an argument that the record must be preserved by the representative asking the questions, and that the failure to perform a cross-examination on a particular point or topic can waive that issue for federal appeal. Now, again, this is all subject to litigation, and of course, there will be arguments that that's not the case, because, for instance, the language used is curious. It says, at the hearing when the claimant is represented, we expect, well, you can expect anything you want. I'm not sure what that doesn't say that there's an affirmative obligation. It says the Social Security Administration has a certain expectation or belief as to what they would like to see happen. Doesn't necessarily mean that it has to happen or that there's a legal obligation now, but there could be an interpretation that this does expand a legal obligation upon counsel or representatives to specifically ask questions. Now, what this means then is, let's say as a hypothetical example, there's an issue with social limitations. There's enough information in the record showing that there could be a limitation to superficial contact, and the ALJ doesn't ask about certain types of contact, superficial contact or occasional contact, to the vocational expert. Now, it raises a question. If you, as the representative, do not ask the question, are you waiving that for future appeal? To me, this raises a question as to whether or not you as the representative need to preserve all issues for appeal. Of course, again, like I said, this is going to be something subject to litigation. And of course, our argument is going to be that this does no such thing. But nonetheless, it's something that has to be considered. And what it does is certainly does create, at least until litigation is complete on all these issues, a burden upon you as the representative to ensure that you're properly cross-examining, to make sure that you're preserving issues just in case the litigation doesn't turn out the way we would hope. So you need to know that you under this new rule, it's important for you to ask questions, develop cross-exam. Gone are the days where you can sit silent after a vocational expert testifies. You're going to have to develop the record. Again, I don't like this rule. I think it shifts a burden at step 5 to attorneys and reps, where the burden is strictly and solely on the government. And that's why I think there's going to be some litigation over this. But nonetheless, you have to be prepared, at least for the time being, to do a good cross of the vocational expert. What else here? We have the other thing that's interesting, though, is what we discussed is the ability to use other documents and treatises, and the fact that vocational expert can use their knowledge and training, I think eliminates, or there's an argument that eliminates sometimes the ALJ's efforts at just ignoring certain limitations. So I'm going to give an example. Let's say there's a limitation to brief and superficial contact that is opined for by a doctor. And the ALJ's analysis of that doctor determines that the term brief and superficial, or just superficial, or whatever it may be, is a vague term that has no vocational relevance. Typically, the reason why the ALJs do this is to get around the superficial contact limitation, which in my opinion is very much relevant, but ALJs don't like this kind of term, and so they try to get around it. And so they find an easy way to get around it by claiming that it's really not in the DOT. So it's not relevant. Why is it not relevant? Because it's not in the DOT, but that's now changed. I think now in certain situations like this, there's going to be an argument that the ALJs can no longer skirt certain terms and get around them by saying it's not vocationally relevant. Because how is it that the ALJ would know? They're not an expert. They're not a vocational expert. And no longer is it the case that they can just open up the DOT, take a look at the DOT and see if that term is in there or not. Because now the vocational expert can rely on the DOT, can rely on the SOC, can rely on ONET, can rely on any number of other treatises, can rely on their own knowledge, their own training, their own experience. And so for the ALJ to unilaterally make a decision that a term is not vocationally relevant or it's too vague, really, I think it circumvents the purpose of the vocational expert being at the hearing. You have a vocational expert at the hearing, ask the vocational expert if it's vocationally relevant, because a vocational expert now has a whole host of different methods to reach an opinion and support an opinion. So I think that now there's also going to be an argument that the ALJs will have a duty to develop the record to some extent on certain points and topics that they would normally be able to try to get around by saying, this is not vocationally relevant. I don't like this term. I'm going to ignore it. I think that may be a thing of the past. And if they try that, I think that could raise legal errors or arguments that there could be a legal error, because the way this rule is reading is that it's up to the VE to make these decisions. The record is developed by the VE. Whether job numbers exist or not is by the VE. Whether certain things are relevant to vocational, the ability to work is up to the VE. And I don't think any longer can ALJs get around that, especially when the vocational expert now has all this information at their fingertips, and it's no longer just the DOT. So I think that this rule in some regards can help certain types of arguments. On the other hand, it hurts other types of issues, and of course raises a very serious concern over whether or not you now have a very serious obligation to perform a quality cross-examination in every case. So be prepared for ALJs to tell you to hurry up on your cross, and be prepared for you to say, I'm sorry, but the SSR, the new SSR, gives me an obligation, and I have to adhere to my obligation. And this may mean this is going to be an hour and a half or a 2-hour hearing. You know, if the ALJs don't like it, they should go back and change the rule again. They should advocate for that. But you are an advocate, and your obligation may be to give some pushback in these situations and develop the record. This is just another example of types of occupations, or rather occupational information that can be used: the SOC system, U.S. Bureau of Labor Statistics, the ORS, all items, documents, treatises that you should be familiar with and ready to cross-examine on. Once again, this says VEs would need to explain the general approach of how they compared the DOT data to data about estimates of job numbers in OEWS and the SOC-based class system. Again, this shows that there is a need for the ALJ to explore the methodology of how the numbers of jobs in the national economy would derive. Again, in order to come to a conclusion as to what the significant number of jobs are in the national economy, this really seems to say that the ALJs now need to establish what that methodology is. And I think simply vocational experts saying, well, it's got 10,000 or 15,000 jobs in the national economy probably isn't going to be sufficient without more. And this here says that our adjudicators are responsible for evaluating VE evidence within the context of the overall evidence in the claim. I mean, it means that VEs are used, but it's ultimately ALJ has to develop the record. This is, again, raises a question as to who's got what burden, who asks what questions. The adjudicators are responsible for evaluating the evidence within the context of the overall claim. Yes, but does that also mean or imply that they have to be the ones to continue asking these types of questions and developing the record? Or is it the attorney's responsibility through cross-examination to preserve the issue? Again, these may very well become issues for litigation down the road. It's going to depend on how these ALJ decisions are written, but only time will tell. So if there's any changes to this rule or case law that develops over time, I will make every effort to try to have more information sent out to everybody so that we can keep everybody updated and apprised over time. This is going to be a changing landscape with this new rule. We don't know how things are going to shake out. We don't know what issues are going to be raised or when, but I wanted everybody to be aware of these issues, to take them under consideration, to think about them a little bit. And like I said, as things develop and as things change, I'll keep you updated as best as possible. Right. Thank you, everybody, for watching. And if you have any questions or comments, really feel free to reach out to me. Feel free to drop an email. I'm trying to keep abreast of all of this and take everybody's thoughts and opinions under consideration, because I think with the change in the rules like this, it's going to be a learning process for everybody. All right. Thank you very much for watching, and have a wonderful day.